Let me start with the most important public service announcement. Switch these things off, please. I mean, put them on silent or whatever, but... And if everyone will settle down, we could get this show on the road. Folks, if you'll settle down, we can get this on the road. Let me introduce myself. I'm Devanshu. I was supposedly the commissioning editor for this book. And now we can get into the formal speech. Distinguished guests, it is my pleasure, my genuine pleasure. Can you hear me? Okay. Distinguished guests, it is my pleasure, my genuine pleasure to welcome you all on behalf of Jagannath. I was worried about the weather. Thank you so much for being here. And I can promise you that this will be a very interesting discussion of what is actually a fairly unusual book. As the commissioning editor, I must confess, I was kind of worried when we embarked on this project. I knew next to nothing about the Supreme Court. Murli was a debut author, editor. What could possibly go wrong? So it actually turned out that I had very little to do and nothing to worry about. Murli and his team put together a really stellar list of legal luminaries and persuaded them, never mind how, to write. I went along for the ride. I read the essays as they arrived in my inbox, asked silly questions, and basically signed off on what was being written. The domain expertise in this book is astonishing. So is the breadth of the number of topics tackled. I suspect that even long-term members of the legal community, and there are a lot of you over here, will find it illuminating. For a layperson like me, it was revelatory. The Supreme Court, the way it works, how judges are elevated, the nuances embedded in every kind of consequential judgment. They're all discussed in detail. You will note that the subtitle of the book has a critical in it. Critical means things have been looked at carefully. It doesn't necessarily mean that the book consists solely of criticism. I was also I must confess again that I was very pleasantly surprised. A lot of the book is actually a fairly entertaining read. It's obvious that the legal fraternity doesn't reserve its wit and humor only for, asides in court. Quite a few of you write entertainingly. In addition to the essays, the book carries several in-depth interviews of legal people who have long careers, and that's interesting in its own way because someone like the lady sitting in front can give you a longitudinal view of how the court has evolved and actually how gender relationships within the court have changed over a long period of time. The book also has an essay by journalist and political activist, social activist Sainath about the topics like rural distress, equity, places where the court may not have been entirely successful in delivering complete justice, which brings us back to the title of the book. Finally, for me, the icing on the cake was this lovely selection of cartoons centered on the law and its workings. I think readers will be both enlightened and entertained. However, while I can wholeheartedly recommend the book from my side, and I admit there's a certain amount of bias involved here, I think Murali and his distinguished panelists will be able to tell you much more. So, without further ado, let me just introduce the panelists. Professor Gopal Guru is a well-known political scientist. He is perhaps one of India's foremost Dalit scholars and Ambedkarites. He's taught at JNU. He's been a visiting professor at Columbia, at Oxford, at UPenn. He's edited the EPW, the Economic and Political Weekly. We're glad to have you here, Professor. Justice retired Abhay Oak started his practice in 1983. He's been a judge since 2003. He's been a justice at Bombay High Court, Chief Justice at Karnataka HC, and a judge at the Supreme Court. I'm not really going to introduce our author-editor. I think everyone here knows him. I will say that he has had a stellar career as a judge, first at Delhi High Court and then as CJ at Orissa and at the Punjab and Haryana High Court. And Manisha Pandey of News Laundry was kind enough to say that she would be moderating this discussion. Manisha also, I think, doesn't really need to be introduced because she's done a lot of work on and around the legal space. And of course, she's a very well-known journalist. So, without taking up too much more of your time, let me just hand over to Murali, who will tell you more about what the book is all about and what today's discussion will be all about.
Good evening. Thank you all for coming out in such large numbers. I'm deeply honored that many distinguished members of the judiciary, past and present judges, very distinguished academics, senior lawyers, and many more who are deeply concerned about the law and the institutions of law are here this evening. A judicial institution is a repository of memories. In the 75 years of its existence, the Supreme Court of India has built a massive trove of institutional memory, comprising events in people's lives, momentous and mundane, triumphant and tragic, of actions and omissions of the institutions of state, the executive, the legislature, and the judiciary itself, of non-state actors like companies and so on. Where these are in the form of written judgments and orders, and therefore largely in the public domain, they are accessible. But these only form a part of the larger judicial record that still remains inaccessible to the legal researcher and historian. Then there are memories that people have of the institution. The Supreme Court has sometimes been visited and oftentimes observed and studied by litigants, lawyers, reporters, academics, legal scholars, and students who have written or commented about their experiences. This is another significant resource for the legal historian. Delving into these sources, the 24 contributors and 6 cartoonists have presented before us their analysis of how the court has responded to the issues brought before it, how it has viewed those coming before it, and how its actions have impacted the destiny both of the country and its people. The overarching tenor of the book is critical and reflective scholarship that can contribute to the debate and discussion around judicial reforms. I don't want to keep this for the last, because what usually happens is by the time the function ends and somebody says vote of thanks, people are already dispersing. But you can't have such a collection of contributors, and they really, with their contributions, have made what the book is today before you. So I would begin by acknowledging, and I wish all of you to also acknowledge some of these contributors who are present physically with us, and many of them who are watching these proceedings online. This is being live streamed. So I begin by wholeheartedly thanking Justice Ajit Prakash Shah, who's contributed the very first chapter on judicial appointments. Justice Madan Lokur. Madan, would you do us the honor of please standing up wherever you are, the working of the collegium. My dear friend Raju Ramachandran, removing and disciplining of judges. Dr. Usha Ramanathan, judicial delay and pragmatism. Usha, wherever you are, please. Rohan Alva. Yes. The Supreme Court and its constitution benches. Ravi is unable to be with us here today. I think Mohini is here somewhere. Justice Ravindra Bhatt. The administration of the district judiciary in India. Challenges and opportunities. Professor Bakshi is again unable to be with us, but he took many precious moments, and we've had an interview, in-depth interview with him on social action litigation, which is what he likes to call it. He always corrects us saying it's not PIL, it's SAL. Rebecca, ma'am, and John, deeply honored, Rebecca, that you could make it here. The Supreme Court Criminal Law and Procedure. Nitya Ramakrishnan. Please, Nitya, wherever you are. Okay. Normalizing the exception, deviant legislation in the Supreme Court. And Vrinda Grover. Crime and punishment, the uncertain trajectory of sentencing. Professor Faizan Mustafa has written an article on Article 30 of the Constitution. Professor Mohan Gopal, Mohan, please. The Supreme but pro-caste, how the jurisprudence of the Supreme Court of India preserves and protects India's caste system. My dear friend Sainath. The top court and the troubled countryside. Indra Jaisingh. Again, an in-depth interview. She was so patient with us, answered all our questions, went through the transcript very carefully. Reflections on gender discrimination in women lawyers. Chandru, who's come in all the way from Madras. Jai Bhim Chandru. On labor laws in the Supreme Court. Justice Gautam Patel, who's unable to be here with us. Consistently inconsistent. Environmental law in the Supreme Court. Arvind Datta, senior advocate. Cases that have shaped the tax landscape in India. The young, bright Gautam Bhatia on media freedom. The young, energetic and prolific Suhrit Parsadi, the 10th schedule to the Indian Constitution. Dear Amit George. Amit, please, let's give it up for Amit. Judicial Review of Arbitral Awards. Is Meenakshi here? We've done an in-depth interview with Meenakshi Arora on advocates of the Supreme Court. the respected senior advocate Gopal Subramaniam, I don't know if he's here. Recollections and Reflections on the Bar, Professor Kamala Shankaran, Legal Education in the Supreme Court. Sriram should be watching these proceedings live. Mr. Sriram Panchu, Senior Advocate from Chennai, the Supreme Court in the next 25 years. I must say, cartoonists are, there are 6 of them, beginning with Rachita Taneja. I think we should give it up for them. Satish Acharya, Manjul, Sandeep Advayaru, Pencil Ashan, and Rohan Chakravarti. So if we want to know what people feel about the Supreme Court, or not just about what lawyers, judges, and law academics and scholars feel, I think these cartoons tell us immensely, with great lucidity, what they think the Supreme Court is all about. So I'll just discuss this a bit more very soon. I also want to thank my 2 young colleagues who've assisted in the editing of this book. Nini, please give it up for Nini Susan Thomas. And Maitreya Subramanian, who's obviously watching all this from New York. He's gone there to do his LLM. And then we have Antra. Is Antra here? Okay. Antra, who's designed the book cover. I also wish to thank the Juggernaut team. So there will be many of them, of course, beginning with Chiki Sarkar. She's just entered. What timing? Devanshu Datta, who was speaking to you just now. And a big thank you to Nishta. Are you here, Nishta Kapil? Riya Gupta, Krishna Savant, for making this, because, after the articles come in, and there's a lot of work to be done in getting it into the final print. I also wish to thank Rupali and Sumedha. They helped us with the initial reading of the essays. I also wish to thank my office colleagues, Karthik, Palak, Yash, and Megha. They've all done their bit. And my own secretary, Nitin Sharma, Raju, Shravan, they've all worked to make this happen. I wish to thank Adalat AI, who transcribed some of the interviews for us, and that speeded up the process quite a bit. I also wanted to thank Zain Bana, who's in Birmingham, where he did the last bit of help with printing out some of the proofs for me to read. If I have left out anybody, please pardon. These things do happen on occasions like this. Thank you, sir. I also wish to acknowledge LiveLaw's help for the live streaming that's happening, and that wonderful team they have here who are covering this event. And of course, the India International Center. These essays tell you about the kind of causes and litigants that have come before the court over the 75 years, and those to whom it continues to remain inaccessible. They speak of the potential of the court to do complete justice at times, and the constraints of the law and procedure that do not enable it to do so at other times. The instances where the law has been made to serve the cause of justice, and those when the court has deterred. The reader might realize that a polyvocal court can also mean that we have 17 Supreme Courts and not just one. That at times pragmatism trumps principle, uncertainties and inconsistencies in the laying down and in the application of the law tend to compound the litigant's woes, and that words final and conclusive in relation to the decisions of the highest court are at best a misdescription of the law laid down by it. The not so infrequent recourse that the Supreme Court does, and only it can, to its powers under Article 142 of the Constitution to do complete justice, even where well-intentioned, can still have unintended negative consequences or leave the task half done and unfinished. This explains to some extent the choice of the title of the book. I'll now just run some of the cartoons past you to see how powerfully, with a few strokes of the pen, these cartoonists have been able to capture what the court is today, what the judicial institutions are today. So this is the first by Sandeep Advayaru, Can we zoom in a bit? No. So it so perfectly captures, because although in the public domain, judges do speak of bail being the rule and jail the exception, what happens in individual cases is something else. And this is so well captured by Sandeep Advyaru. I then move on to the next cartoon by Satish Acharya. You know, Suhrit Parsari has written a whole article on the 10th schedule. And at least 2,000 words of that article are in the Shiv Sena case. And then Satish Acharya sends us this one cartoon, which just encapsulates that entire 2,000 words with just this one cartoon. I mean, it just shows the brilliance of the man and why we need to preserve this freedom of expression in our country. It's very badly needed. And we must encourage these cartoonists to express themselves fearlessly. The third, again, so brilliantly captured. I know all the legal scholars will agree with me. In just one frame, he's been able to explain the Ayodhya case. It's outstanding. And I saw it, I was stunned. Rachita Taneja is no stranger. Look, and this is the cartoon just before Indra Jaisingh's interview starts. And Indra will agree with me. Nothing could have been captured better than this one cartoon. Just read what it says. The next cartoon, this is on the Great Indian Bustard. I'm sure many of you follow Rohan's work, if you're readers of the Hindu. And this article by Gautam Patel has one whole section on the Supreme Court dealing with the Great Indian Bustard. And when I saw this cartoon, it was almost as if we had commissioned, Rohan to draw up a cartoon for that piece. And Patel was stunned. So Patel now has asked Rohan to do a larger mural for him, for his office. And this is goes with my digitalization piece, which is one of the penultimate pieces of the book. So, this is a very common phenomenon. Many lawyers in this room will understand what is happening. And this is by Pencil Ashan, who's actually based in the Middle East, but he's from Kerala. He has nothing to do with law. But what he has observed, he's able to so perfectly capture. And there are many more cartoons. I think Manisha is planning to discuss some of them. So, this is the cartoon part of it. I still want to go back to Sainath, because he's the only non-lawyer who has contributed to this book. First, Sainath had doubts. He says, what am I doing in a book on the Supreme Court of India? And I said, no, it's very important for your voice to be heard. And if anyone reads this chapter on the top court and the countryside, they'll understand what it is all about. But the cartoon that precedes this chapter is this. And Sainath will agree with me. This is exactly what he was seeking to convey. Just see this carefully and you'll know what is being meant. So I'm often asked by people who know that I was a lawyer in the Supreme Court for about 20 years, then went onto the bench and came back in 2023. So they ask me, what do you think has changed? So I've thought of this often. One thing that's definitely changed are the hybrid hearings, the live streamings, the live tweeting in real time from the court, and paperless courts, paperless lawyers, and some of the judges willing to go in that mode. It's a more rushed court. I think Ajay is watching, just as Ajay Tiwari is watching from there, finding out what I'm going to say. It's a more rushed court. It's more chaotic. There is more miscellaneous work. This is a jargon that lawyers will understand, and less of regular work. And the new players in this whole scenario are young people in the form of law researchers and interns. Now, each Supreme Court judge has as many as 4 law researchers. Even High Court judges have at least 2 law researchers. And there is a whole army of interns floating around somewhere, in the campus. So through them, you get to see a lot. What has not changed are the ushers. The same liveried ushers who come in, and warn you that the judge is about to come. Typically, the usher will come with the gown on his sleeve, on his hand, and he'll come with the pen of the judge or the specs of the judge. Then the judge is not far behind. And that hasn't changed. So I've often wondered if these stories, if this vision of the Supreme Court were to be narrated not by lawyers or judges, but by the ushers, how much more interesting that reading might be. I remember the usher of one of the former Chief Justices of India, who many years after the judge had retired, in an aside, told some of us in a conversation that, around 12 o'clock, you would see me get onto the dais and bring a flask for the judge, and you thought it was hot water. It was spirit of a different kind to keep his lordship happy. And then you have law researchers who are now coming out. They can't control themselves. You see social media. So law researchers can't keep quiet. So one law researcher, there's a study done on the law researchers of the Supreme Court. It's there in the public domain. One of them was asked to prepare 2 drafts of a judgment in a case. One allowing the appeal, one dismissing the appeal. For my lord to choose which one would work. So if we have the narratives of the court spoken in different voices, we might get to hear even more stories. But all that, I suppose, is work for the future generations. What does give me hope, though, and this is the present bar, that we have a younger and more vibrant bar, more women lawyers and seniors, far too many advocates on records, which has its own set of problems, and also far too many seniors, including myself, who's come back to the bar. But I think there is hope, because some of these young lawyers are doing some very, very difficult cases. They're going out to the prisons, meeting prisoners, picking up their stories, coming back, litigating, getting the truth out, and getting to ensure that justice is done. And all this not for any reward, but sheer commitment to the cause. So that gives me great hope for the future of the bar. And I'll end with this. The stories narrated here capture moments of triumph, of reinforcement of one's belief in the Constitution, of deep disappointments, of frustration, of hope, and of despair. Everyone lives on in the hope of that better day, which does make an appearance, although not as frequently as is hoped for. But even to those not so sanguine, may I recall the words of the renowned historian Howard Zinn, who in a 2005 commencement address titled Against Discouragement said, and I quote, "The lesson of history is that you must not despair, that if you are right and you persist, things will change. The government may try to deceive the people, and the newspapers and television may do the same, but the truth has a way of coming out. The truth has a power greater than 100 lies." Thank you. Thank you very much. I'm also deeply honored that Justice Oak, Professor Guru, and Manisha have agreed to be on the panel at my request, and we can start the discussion straight away. Thank you. Okay, let's do that. Once done, both of them come. So please come. I sit here.
I think we must formally launch the book. Yeah. Yeah, we can hold it up. We can hold it up.
Oh, I didn't get it. Yes, I can.
You can share with us. Great. Thank you so much, everyone, for turning up. It's such a lively crowd, and I hope we have a useful discussion for you over the next 40 minutes. I want to set the tone of our discussion with a cartoon. Can we have that up, please, here? So this is a cartoon that says, you can see it, and it says, "I don't know why you're all complaining. I feel very represented." Okay, that's all the Supreme Court judges. And it says, you can see in the pie chart here, few women, fewer Dalit, not enough religious representation. And I chose this cartoon not because it's right on the first chapter by Ajit Prakash Shah on judicial appointments. That would have been the lazy thing to do, and journalists are not known to be lazy. So I didn't choose it for that reason. I didn't choose it because it really resonates with me as a journalist, because we have the same problem in the media. We've done a survey in News Laundry where we looked at top newspapers, top channels, digital organizations such as ours, and found that almost 90% of the leadership roles are taken up by upper caste individuals. There's very little of representation from the scheduled castes or the scheduled tribes. So it resonates with me, but again, that's not the reason why I chose this cartoon. I chose it because it made me think about something, which is that we are discussing 75 years of Supreme Court at a very unusual point in our democracy. An average citizen today feels let down by many aspects of our democracy. We are tired of our self-serving politicians. We've accepted it. We are fearful of law enforcement agencies, and there's no better symbol of this than the digital scams. Think of it. An average citizen thinks that it's entirely believable for law enforcement agencies to extort money off them for crimes they've never committed. So that's the level of mistrust that people have, that they get scammed. And there's actually a scam around this mistrust. And then you have the media, of which I am a part, but large sections of the media have forgotten public interest. More so, I would say, over the last decade. The loudest, noisiest channels are decidedly anti-people today. And so you have a situation where a common person looks up to the Supreme Court and says, you come through for us, right? We're let down by these aspects, and we're looking at you. And I guess what I want to think about over the next 40 minutes is, how fair is that burden when the Supreme Court itself is grappling with the issues that plague our society, like this cartoon shows here. This is not just a problem of the judiciary, this is who we are as Indians, and that's reflected in the higher judiciary. So with that, I want to start with opening remarks. Maybe Justice Oak, you could come in with your opening remarks on the book, and then we could go to Professor Guru and then start our discussion. You prefer the, okay. Okay. Okay.
Good evening. I must confess that I feel very awkward for two reasons. One is my senior colleagues in the Supreme Court, my colleagues in the High Court, many distinguished senior advocates are sitting here from whom I have learned so much. And I feel that most of them should have been here and I should be there to learn from them. But Murli gave me no option. The second reason why I feel awkward is I'm not good in public speaking. I have gone through the entire book. In some of the articles I read repeatedly. My first comment about the book is, I think cartoons speak more than the written material, written articles. And the most important part which I liked was the introduction by Justice Muralidhar, my old friend. He says that he wants to trigger discussion and debate. That's most important. When we think of institution like judiciary, or for that matter Supreme Court, I believe that no institution can be entirely good or entirely bad. I have often said about this in law schools that celebrations started, so-called celebrations started after we completed 75 years of existence of Constitution. In fact, as far as members of the legal fraternity are concerned, it did not really, the celebrations were not warranted. Introspection was required. Introspection of both aspects, where we have succeeded and where we have failed, where we have gone wrong, where we need course correction. But that did not happen, and the great success of this book is it is going to trigger the discussion and debate, as Brother Murli has said. After going through the articles, I must confess that I have learned so much. My tenure in Supreme Court was only of 3 years and 9 months. I had very few opportunities to come to Supreme Court and see Supreme Court in action as a lawyer. And therefore, for me, when I read, I went through the articles. There's so much new to be learned. In fact, every article is worth referring and worth quoting. But only few things which I want to say. One article which stands out is by Brother Justice Ravindra Bhatt, because he has rightly discussed the poor condition or pathetic condition of our trial judiciary. In fact, I have gone on the record saying repeatedly that the biggest mistake we committed during last 75 years was that on such public platforms we kept on discussing only the High Court and Supreme Court, but we neglected our trial judiciary by referring it as subordinate courts or lower courts. So he has given facts and figures. He has talked about the poor condition of infrastructure. My dear friend Justice Gautam Patel has really made a point while he discussed issues of environment, which are really very dear to me. And something which I wanted to say in my judgments, and which I tried to say but not in so many words, which he has said in the last part of his article, and I want to quote that. It is simply no longer possible to cling to the notion that larger projects have no alternatives. This is the most important sentence in the article. And lastly, he says that this is not a narrow concern limited to our country. Governments will always promote big spending and large projects, and it is up to us to demand viable alternatives. I was fascinated to read only one sentence in interview of Indira Jaising. I read only one sentence. I think it is a myth that women judges are better able to address women's issues. She has spoken the truth, which we say day in and day out, those who are part of the legal fraternity. Rebecca John also was very candid. I think Brother Murli spoke about it. She says that the SCI itself speaks in different voices, and one bench does not necessarily follow or consider the judgment laid down by a previous bench. The tendency of treating judgments as expressions of personal ideology or cults of personality leads to an undisciplined jurisprudence. It is so true. I don't want to spend more time because we are waiting here for this panel discussion. Only thing which I want to say at the end is thank Brother Justice Muralidhar, because this is the debate which is required. And when we debate on this issue, we must deal with where we have gone wrong, where the justice rendered by Supreme Court was incomplete. But wherever the Supreme Court, the great judges, have done a great job, we must acknowledge that also. Do we have judges who will say to his wife that, look, I am delivering a dissenting opinion and I know that this is going to cost me the post of Chief Justice? Do we have judges who will tell the persons in power that if you make me Chief Justice by superseding somebody, I'll step down? In fact, these are the real traditions of the Supreme Court. This is the real glory of the Supreme Court. And lastly, I think one more debate is required. Look at the number of cases filed in the Supreme Court. Filing is ever increasing. We lay down the law which binds the entire country. In fact, we deal with the lives of individuals, so many citizens, so many individuals who stay in our country. And we deal with 60 cases on non-miscellaneous day after notice matters. We deal with 30 regular matters on Thursdays, 70 or 80 or even more matters on Mondays and Fridays. This is an area of concern. Where is the time for application of mind? If we are going to spend 6 hours every day in reading the files, at the end of the day, lot of time in correcting the orders. I mean, where is the time to think? Where is the time to deliver judgments? This is one area of concern. The sheer numbers is the area of concern. And some reasons we must find out. I said that one concern was where in a magistrate tribal case, where normally magistrate should be granting bail or sessions court should be granting bail, now people have to approach Supreme Court. There are reasons and reasons, but we need to have debate on why there is a huge filing and consequently huge pendency of cases in the Supreme Court. I thank the publishers and the author for giving me this great honor. Thank you.
Hi friends, I must thank Murli for inviting me to speak about the book, and I feel equally awkward to speak about the book when I am coming from outside, not from inside. And since I am coming from outside, I can afford to be adventurous, because being insider you have some constraints. As brother, that constraint I don't have. Pardon me if I am really using my wisdom to reflect on the book. I must share with you that the book is worth reading, and reading for those people who don't really belong formally to the area of legality. And this book I would recommend very highly to those people who want to do some insightful research on judiciary and social relationship in this country. Therefore, I would try to reflect on or build on to the terms that have been used by different scholars who form the part of this book. The point that one has to discuss is about the terminology that the judges use and the terminology they hide in their some kind of judgmental capacities. For example, in Nitya Ramchandran's essay, the judgment, the observation made by a judge is that, a wrongful prosecution might or likely to lead to caste divide in the country. Now, it can really open up different possibilities of debating what is this likelihood and why wrongful prosecution is going to widen the caste distinction in the society. And she says, I think this is a very incomprehensible observation that the judge has made. I am going to ask this question to all of us, that what is this suggestion? There's some kind of consequentialism involved in this, that you are actually trying to privilege the element of moral duty over reason. And this is in reference to the 1989 Act, that a scheduled caste person is trying to inflate the case, and that would really lead to this kind of division. Now the question is, should we be taking this moral route, or you want to take a legal route to this problem? And I think the legal reasonableness is aimed at actually finding out what is wrong prosecution, what is a wrong prosecution, and what is the right prosecution. What kind of prosecution would really maximize or minimize the prospect of justice? Instead of doing this, the judge is making something, he's going beyond this legal mandate. So one has to find out why this is coming, from where is this coming, and then Mohan might have his own explanation to this. So the debate that one has to start is that whether one can privilege. This is a moral duty of the untouchables to actually find out, to see that they moderate their claims to justice, keeping in view the health of the society, the social harmony question. As if the accused person doesn't have any duty. So, I mean, we can explain this in different ways. So, this is one question. the observation actually creates a wedge between duty and reason. So that is one point I think we should really debate. Second, and therefore the consequentialism is a point that we have to take into consideration while debating legal issues. Second point is about Usha. Usha's essay makes a very, I would say, stunning, not because Usha is present in the hall, but you know, it's a very stunning. The under trials are on the edge of legality. I mean, this is a profound statement she is making. Now, why they are under trials? Because they are already, the truth of being there as under trial is already fragmented. In the sense, they are waiting for their regular trial, but they are denied that trial. So they can't really experience their being as a legal subject. The very identity of legal subject is being denied to them. Now, of course, this is a very subsidized version of being legal. I don't buy into this. Why should I be a legal subject and for what reason? Being under trial. So that's a different issue. But the fragment that is introduced into this under trial is waiting for the trial but not able to do. So he or she is a part of the system yet apart. Now, this goes very close to what Ambedkar was saying. Untouchable of the part, but they are still apart. So this is one, another way of looking at the terminological possibilities and their expansion. Now the third one is very important. There, I think, is the definition of discrimination is important, and that issue of discrimination is raised by Sainath and Mohan, and I think in media, Gautam Bhatia. It is about the bail, promotion of judges. We have to find out what is the subtle difference between discretion and discrimination. What is the level at where you find discrimination is becoming legitimate, and discrimination is not intruding into this legal legitimacy of discrimination. So that is one point was troubling to me. So I thought discrimination absolutely brings to your notice the problem that the Supreme Court is actually creating while defining it. Discrimination formally requires two people and their visibility so as to establish discrimination. If there are no two people, how can you establish discrimination? So definitional condition is having visibility of two people, right? And therefore you can find out the discrimination playing out between the two. But Sainath is making another important point in his essay. Does the Supreme Court have, does visibility provide all the time definitional condition for for discrimination to become legally intelligible? And he says no. The certain people are rendered invisible. They have gone into oblivion. They have vanished. And since they have vanished, the definitional conditions are also eliminated. So what does the Supreme Court do about this? And he mentions about the Kumair case. It took 10 years for the court, for the police to file the charge sheet. I mean, it's amazing in this country. I mean, maybe incredible. So, what does the court say about this? When the conditions for definitions are not fulfilled, certain people are not visible. They are just disappear. They are made to disappear in oblivion. And there are cases. A GNU case is still pending. So that's discrimination has to be defined differently, and we have to negotiate or debate this point. Again, going back to Mohan, and since my introduction was done in a different in a way that I should really intuitively relate myself to my location. So I'm really drawing purely on the experience of the untouchable communities and the essays by Sainath and Mohan bring that new terminology to our discussion.
Great.
Is it 10 minutes?
No, please continue. You can finish.
No,
You
I
have
thought
another
that-
2 minutes, I think. Please go ahead.
Now, he is again mentioned, quoting Sukanya, I think, that there is casteism in the jail. Now, I think the Supreme Court has done something. Some nodal officer is appointed to see that there is no casteism in the jail. Now, Sainath and Mohan share this, that the life of Manu's law is longer than the modern life. Isn't it? And this is my, they are not saying it, but I'm just giving a different turn to it. Now, Manu's law is the outer limit of the modern law. Nothing exists beyond that. And Mohan says, the law not only exists in prison, it exists in the very guts of the people who dispense justice. And therefore, Mohan's article in the book is actually hinting at the critical legal studies to say that you can't just avoid politics while you are doing justice. It's a very important point, I think, that Mohan is making. So, and finally, I think, and I'll make 2 points. One point about Murali's expression, what if, in the introduction, as you very rightly said. What if is a phenomenal expression. As if, even if, and what if. What if? What if the descent of certain judges were to convert into land of the law? He is already suggesting some kind of parallel legal thinking in this country. But dissents are actually monitored and moderated in certain fashion. And you said that very important point. There's a moral strength to it. And please give me 1 minute, maybe 2 minutes, please.
1.5. We'll compromise
okay.
at 1.5.
One is about Advocate Indira Jaising's very important quote, I am going to quote, and Professor Upendra Bakshi, who is actually going to the debate between Justice...
So you'll have to have your mic. You'll have to have your mic.
Oh, sorry. I thought it was mic. And it's just provoking. I was talking to him yesterday that Justice Iyer was a deep thinker, but also had a very deep emotional touch to his judgment. But as Professor Bakshi is known for his legal theory, jurisprudence, he would say too much of, he said, you want to wipe the tears of the poor people, but the handkerchief is tattered. So he is actually in a way coming in with a legal theory background. But let me read out quickly in the same way that Advocate Indira Jaising's very categorical observation, and that requires very deep thinking. And I'm just quoting you, ma'am. When one represents to a court a deprived community, one is forced to be creative in one's argument. One is creative in one's argument. She believes that the letter of the law has not much to offer to these communities. She further observed that the arguments have become like mantras. So I'm just adding to what you are saying. Mantras draw their repetitive power, perhaps derivable from the actual laws that draw their content from the past precedents. What is this? I think she is actually inviting us to think more creatively, insightfully about the cases that pertain to oppressed communities. Thank you so much.
Thank you so much.
Yeah.
Senior Advocate Muralidhar, you couldn't have asked for a better review. These are like amazing notes on the book and the chapters you absolutely shouldn't miss. When we talk about, I want to start with you actually. can we have the cartoon up right before Rebecca John's chapter, which is on criminal laws and procedure? So when we talk about incomplete justice, I think perhaps nothing illustrates that better than Umar Khalid's case. Seen 4 Chief Justices, yet to see justice, by the brilliant Manjul. Umar's case is of course the most stark, and there's quite a bit of media attention to it. There's a lot of conversations around it, but there are many such cases. You had the case of Sudha Bhardwaj, you had the case of Siddiq Kappan, 800 days in jail and then he gets bail, UAPA cases, activists languishing in smaller parts and districts and cities who we don't know of much, who we don't talk about enough, essentially in jail for thought crimes. And I wonder if there is a recalibration of bail is the norm, Freudian slip, bail is the norm and jail is the rule. Is there a recalibration?
I wouldn't see the problem, and Justice Abhay Oak very rightly said, not all judges are good, not all judges are bad. Not all bail applications get rejected, but the percentage, I think we can talk of trends. And this is absolutely right. I've heard him say in anguish in the court, very openly, saying punishable with not even 7 years and you are here in the Supreme Court. I've seen him asking this of so many lawyers and of some of the other judges too. So this is a trend which is disturbing. That there is a mistrust of the judiciary per se when you introduce into criminal law, statutory criminal law, provisions that make it next to impossible for a judge to grant bail. Otherwise, the normal criminal law was more than sufficient. You have to trust the judges. When you, for instance, say that confessions made to a police officer will be admissible in evidence, you're not trusting a magistrate who can record a confession. So you're somewhere disconnecting the judiciary from the criminal law administration, and that's a very serious consequence for fundamental rights of the people. When we talk of procedure established by law, there has to be a trust of the institution. So we don't trust the subordinate courts. I'm sorry to use the word. We don't trust the district judiciary. Now we've stopped trusting even the higher courts. So many people are having to rush to the Supreme Court. And this is a trend that requires to be reversed. It has not yet been reversed. The cases that you point out are episodic. Like day before yesterday, I think Siddharth Varadarajan and Karan Thapar could go. The case was, I think, argued by Nitya, and they granted a stay. But again, you know, there could be many more languishing in our jails who don't have the wherewithal to come directly to the Supreme Court to ask for interim protection. And this needs immediate course correction. I don't think we can put it off, because this mantra of, bail is the rule and jail is the exception, I think people are tired of hearing this. They just want to see it in action, and we need to trust our judges. If a high court judge is going to pull up a district judge for granting bail, I must share with all of you, when I took over in Orissa, and Abhay, you will be shocked to know this, there was actually a circular saying every copy of anticipatory bail or bail, the order granting that should be sent to the High Court. You know what it means when you tell a judge that every bail order you have to send to the High Court. I had to have that circular withdrawn. And after a lecture in the Judicial Academy, I would have many of these judicial officers come and tell me over a cup of tea, so you keep telling us all this, but what if my ACR, that is annual confidential rolls, are spoiled? And it does happen. So if you read the Tariq Pe Justice book by Prashant Reddy and Chitrakshi, they talk of cases where judges have had to face disciplinary proceedings for granting bail. So this has to change. And I think we use all these public platforms to emphasize that we must stand by our district judiciary when they grant bail. That is exactly what they're supposed to do. And we must protest against introducing into even, like provisions like make it impossible for grant of bail, shifting the burden of proving innocence at the stage of bail on an accused. These provisions have been written not just into the UAPA, but the PMLA and the Companies Act and so on and so forth. That trend has to shift, that has to change. So we have to generate sufficient public opinion. I think judges should start speaking more about it even through their orders and judgments.
I think it's very interesting that you brought up the book Tariq Pe Justice, and Justice Oak, you also spoke about the district trial courts. And it's true that actually in public conversations, we end up talking about just the Supreme Court or the High Court, and it's glamorous to talk about them, but we rarely talk about the district courts, what the problems there are, and that book actually highlights very well how judges can face punitive actions there for giving perfectly regular orders. But two things from this: one is the lack of trust that we are seeing because of conversations around bail not being granted. There's a certain distrust which is not healthy for us. And what do you think constitutes incomplete justice? It's delay, it's denial, but there's also the silence of court. Now there are questions around why is the court silent?
Firstly, you asked me about the trial and district judiciary. I think I said that a few minutes back that we have neglected our trial and district judiciary. I think someday we must make a study. I'm dealing with a simple civil suit, maybe a very small person a woman going to the civil court and seeking a share in half acre of agricultural land. Now there is a civil court and there appeal in the district court. So how many cases go by way of second appeal to the High Court? And from second appeal, how many cases go to the Supreme Court? And the study will reveal that there are many who can't afford to go to even High Court. And therefore, that's the importance of those courts. And as Brother Murli has said, it's not exactly about distrust. It is about the treatment which is given to some of the session judges or magistrates when they pass certain orders. There is other element which I want to highlight. Every judge is a human being. We come across cases, even today in our society, there are very heinous crimes committed, say against women. The investigating agency, namely the police, get holds of somebody as accused. And there are politicians, ministers, even chief ministers, declaring that now we have arrested the accused and we'll see that he is hanged. Now place yourself in position of a session judge working at a taluka level or district level. Now there is a social media.
Yeah.
There is a media.
There will be a 24/7 frenzy around it.
That's right. So the judges are also placed in a particular position, and there they look upon the High Court for the support. And that's a great deal of important issue which he has raised, that the High Courts, the High Court administration must support our trial judiciary. The second part, I'm just continuing your question. You know, there needs to be a systematic study of bail granted by a trial court, bail not granted by the trial court. Now, we talked about one case where that cartoon says so. Now, somebody must make a study. How many such cases are pending in the Supreme Court or similarly in the High Court? I think it's all about our priorities. We are not able to fix our priorities. Which case should be given priority? That's the issue. I'm not ascribing any motives to anybody. But can we say that a particular case, say bail application is not being taken up or SLP arising out of bail application is not being taken up, can we attach motives to that? Unless we make very systematic study of the progress of bail application, progress of SLPs which are filed against the bail applications, I think we can't jump to that conclusion. But the fact of the matter is, today we have a scenario where bail should be granted at the threshold. People are not getting bail. And for that purpose, you know, it's not only the judges. The approach, I have attended some of the conferences of doctors. There are associations of doctors in Maharashtra who conduct these legal seminars about medical negligence, about right of accused, right of victim. There is large section of our society which is blaming the judges for granting bail because people don't understand difference between grant of bail and acquittal.
Yes.
You know, so therefore, we of course, as member of the judiciary, I continue to belong to that fraternity. I must accept that where bail should have been granted is not being granted. I must accept that in many cases. But we have to think about the role played by society, role played by media, and role played by prosecutors. That's it.
See, some of these law officers, we find that even though charge sheet has been filed, 3 years have gone by, the person is not required for an investigation, trial is not going to begin, you will have even law officers in the Supreme Court vehemently opposing bail.
I think it's a very interesting point you make. I hope you can hear me, or maybe we can fix this.
Yeah.
And otherwise we'll have to keep. Okay. So I think you made a very interesting point, and I want Professor Guru to also come into this. This thing of opposing bail, and especially because of the media pressure or social media pressure or just, you know, the frenzy around the case, and especially in heinous crimes we see when somebody's been caught, there's this immediate need to, you know, instant justice, and sometimes you've had cases where there have been immediate encounters, quote unquote. So there's that too, where it's a problem of society, and ultimately the judges or those who have to dispense justice are going to be influenced by what the chatter around a particular case is. And in high profile cases, at least there's media scrutiny. But there's so many such cases in districts and smaller cities that don't get our attention.
I think I am still very skeptical about the term used, prima facie. What is this? This is, I mean, the charge is true and untrue as well at the same time. So how does how does a judge take a call to say that this has a potential of granting the bail? And that prima facie has become a very, very magical word. I mean, you just don't know what to do with this word. It offers a great escape route for those people who actually live with the prejudice of against women, against Dalits, against oppressed. So in that, I mean, in this situation where there is an advantage for playing out your own prejudice against women or against Dalit, there should be. Is there any mechanism to see that, you know, your capacity to grant bail becomes foolproof? I don't think there's any provision in the law manuals or law books, or even the debates that took place, even the reports that were written about the very text of quality books. So that, and so in the absence of this clarity about this thing, people take advantage. I mean, social media and all those people take advantage to pressurize. And why they don't need to pressurize? They have become law themselves. You know, they deliver judgment. They do all kinds of things. So I mean, there's really a challenge before the judiciary in this country to see how to really handle this parallel system of judgment. Now, Sainath was referring to a case in Tamil Nadu, a person who is, and I mean, Murli knows it, so a Dalit person has been appointed, and he's from what is called Ghana. What is this, Sainath? Where are you?
There he is.
So that person, and he has been appointed as a lecturer in a college, and the college has, and judgment, and the High Court has said that yes, the appointment was legitimate, all the proofs, all documents are in place, and yet the court is not, the court has dismissed him. Now, I mean, there is a law beyond law. There is a law beyond law. And so how, I mean, the formal system of justice has so much to really handle. Now, you can say, so you can, I mean, Kamla and Farzan Saab wrote about education and your judiciary at Bhopal. But when my experience of Bhopal, and Mohan sent me there one day, I was so much disappointed that no one would talk to me.
For those who don't, I mean, Professor Guru is referring to the National Judicial Academy.
National Judicial Academy, Bhopal.
And he's talking about his experience of talking to judges there who come for the training. Yes.
So I talked about the very difficult issue called reservation. So they had their own mind, so they didn't want to open up. So I mean, all right. So I think it's such a deep problem. As I am as an outsider, is so worried about the whole thing.
So you're not an outsider.
Can I add only one thing?
Yes, please do.
Since we are on bail,
Yeah, we're on.
yes, of course, I have said,
Are we on bail?
I have said
There's another cartoon
See,
of Stan Swami, sorry, Professor Saiba.
no, while we discuss bail, and as judge also endorsed this, that bail is the rule and jail is the exception. But we can't ignore that in certain cases, law requires judges to reject the bail application. That also is something which we should consider. But there are cases and cases where person who is released on bail has gone and threatened the victims. It happens in case of offenses against women.
Yeah.
So when we discuss bail, and I was the one who always said, you know, that judges have to be liberal because there is Article 21. But at the same time, we cannot forget that there are cases and cases where bail has to be refused. And it can't be that a judge who grants bail is a good judge and a judge who refuses bail is a bad judge. We can't have that
Yes,
outlook
we
also.
can't. I'm told that we're running out of time, but I want to have one. Are we? Do we still have like 15 minutes, and then we can take on the questions? I want to move to media. Question to you. We have a situation now where the media is both the victim and also a perpetrator sometimes. So you have endless trials. You have reputations being ruined on primetime news. You have real life consequences of media trial that we see today, including jail. And then you have independent, public spirited journalists who are slapped with FIRs, who are slapped with defamation cases, also with UAPA cases for simply reporting, simply news gathering. Do you think we've done enough to protect freedom and also protect people who are victims of media trial?
Actually, that's a no-brainer because we've not done enough. So again, media is not really free because it's subject to so many pushes, pulls and pressures. There's corporate ownership of media. So when the media is taken over by a corporation, by a powerful, let's say, company, the narrative changes. And again, media, since it depends on advertisements of the government, and this is something I think you in your channel keep on saying, pay to keep news free. So, you know, they are now constrained to walk a very tightrope. I'm talking of even something like, you know, Indian Express. So they have to make sure that they have both points of view, and, you know, it's a balancing act. You can see that's happening day in, day out in newspapers. So media is really not functioning in a free and accountable manner. So you're talking of accountability of the media, which is not able to be enforced. You're talking of freedom of the media, which is definitely being curtailed through a variety of instruments. So like raids on media houses. Yeah. And so many of you have to go online. You have to, you know, depend on social media and that kind of influencers. So the nature is changing because of the controls that are placed. And this is not just peculiar to India. It's become a global phenomenon. So I think you should tell us something more. In fact, we've not heard from you. You should tell us about, you know, the pressures that media houses face and the tremendous, harassment in having to run from a police station to a court and then to the High Court and the Supreme Court. It must be taking up so much of your time as well, right?
Yeah, especially for like smaller media organizations. And I think one thing which has interestingly happened over the last few years is the misuse of copyright laws, where a lot of us have had to, we've had our content pulled down because the people that we are critiquing use copyright laws to strike at us. And I think in this case, there's one very interesting case of this channel called Being Human. I'm sure a lot of you are familiar with that. Ramit, who basically he would take content from other channels, but to mock what they're doing. So it isn't a copyright violation, but there was a copyright case which they lost because they couldn't explain to the judge what a meme means. So he told me that, I'm just unable to explain that it's a meme. It's not a copyright violation. So I think there's also that, how our language changes, how our critique changes. The courts have to be abreast with what's really happening here. It's not stealing content, it's using it. It's pretty much like what cartoons do. Memes are kind of the new cartoons. But there's the other aspect also.
Can I just add one thing?
Yes,
please?
please.
Sorry, I should refer to Gautam Bhatia's very important piece in the volume. That what he is saying is that, the media, so-called corporate media, has actually has become so free after neoliberal policies of the government. Earlier, and the case he's talking about is the case of the Sakal. The court took the decision then that there should be balancing between the price of the page and common good. The common good should not be compromised or sacrificed for the price of the gate. So the numbers of advertisements and all that have to be decided in proportion to the common good of the people. But that burden is gone off, and that's a very important point Gautam Bhatia is making in his research. So political economy also is very important.
There's the other aspect of the media, which I think is very interesting, and we should know this from you. We have LiveLaw as partners, and there's bar and bench, and there's live tweeting now of every hearing, and you're quoted. You can be even an observation by a judge can make front page headlines, can be a trending hashtag, can be a source of a meme. So the scrutiny and the 24/7 coverage, especially on social media, what's happening in the courts, we welcome that. But is that changing the way judges are conducting themselves in terms of even observations, how they write a verdict?
See, two things about it. Personally speaking, I developed art of ignoring what media says. That's the best strategy for a judge.
Can one really ignore, though? I always wonder. Because you obviously look at...
I will tell you an interesting thing. I go to judiciary academies. I went to a judiciary academy where I have interactive sessions. There was a session judge who conducted a trial, a relatively small district place, but for that place the trial was very important. So he said, sir, even before recording of evidence, somebody said that this judge is going to acquit the accused. So what do? I said, don't worry. There will be other media people who will say that judge is bound to convict the accused. So don't go by that. One serious thing about this live reporting, I want to say something. We as judges, I have a case. Somebody is arguing a case. Sometimes suppose I am hearing a petition, the Article 32 petition. I don't decide after reading the case at home. Sometimes I indicate what is against the petitioner. And in so many words, maybe very strong words. The idea is to bring best out of that lawyer. But he must know what is against him. But due to this live tweeting, what happens is that what just said is projected. And then after a few days you say that judge had decided exactly other way around.
The opposite.
Because the reason, this is the process. If I want to get best out of the lawyer, I must express my view. This is my prima facie view. Prima facie I am against you. Only if I say that, then lawyer will be able to effectively argue that. That's one thing. So to that extent, see, those who belong to legal fraternity, they don't get carried away by this live tweeting. But lay persons, even highly educated lay persons, they sometimes get influenced, but I am not bothered about it. I have only one worry about media. Many cases I have seen. One classic illustration I want to give you. Not that I hardly any occasion to watch TV, but the day judgment in NJSC case was pronounced, it was 1,000-page judgment. NJSC judgment, 1,000-page judgment. At 11 o'clock I put on some news channel. There were lawyers who were analyzing that judgment. Is it physically possible for anybody to go through 1,000 pages?
That is the peril of 24/7 TV, and I think it's not, you are not the only victim of that.
My only worry is, see, I have seen two reporters, Madam Indira Jaising will know, two reporters in Bombay High Court. After the judgment was pronounced, they used to go to library. They used to cross-check all references, they refer to all judgments which are referred in the judgment, and then say something about the judgment. So that's the only area of concern. When important judgments are pronounced, before it is fully studied, comments are offered.
Professor Guru, good, bad, what do you make of this 24/7 scrutiny, live tweeting, live analysis? Is it good in a way that everyone's on their toes and careful about the words they use, how they frame their sentences?
I mean, today, you are in such a great hurry that you want to rush to the conclusion rather than reaching to the conclusion. And we are just doing some kind of 2 minutes Maggie thinking. So I don't know, that would really help a very serious legal practice in this country. You need to have some kind of a very, it's called, what is it called, infrastructure of thinking. You require to spend a little more time and read this book and how it is carefully and diligently done by all the 24 authors. I don't think there's any option to this short-circuiting of your argument through media and digital things. So I'm against AI, basically. Yeah.
Okay.
Yeah.
Okay.
Can I add something
Yes, please
about
go
live
ahead.
tweeting? You know, there's one.
I'm a fan of live tweeting. I must say, I
No,
really
correct.
appreciate LiveLaw and Bar and Bench
Right.
quickly telling me what's happening. So then, but please go ahead.
See, there is one good feature of live tweeting. Suddenly, people who don't have cases in the court have realized that court is something very interesting.
Yes, it's got the public interested. That is. What do you think? Do you think? But on the central question of does it? You think it's changing the way judges are wording what they're writing, their observations?
No. I think the court is a theatre of performance. There can't be any doubt. And some judges, some lawyers will use that space to perform. It's a human tendency. We've had lawyers who make an argument, then turn around, actually literally physically turn around to seek approval. I know Justice, they'll all know whom I'm referring to. But this is true. It's a human tendency. You know, today now those clips, the live streaming clips, are all being used in YouTube. Somebody says angry judge, brilliant argument, and that kind of a thing. It's inevitable. I think in a democratic space, this kind of a thing will happen.
Do you welcome that? You think that's...
I think it's part of that churning itself. When you open up court spaces, these things are bound to happen. But we should be able to rise above this and be able to handle it. In fact, one of the judges giving a dressing down to an IAS officer saying you did not come in your jacket. And it did have a backlash. And I think it was important for people to know that some judges think like that. So I'm just saying it's better that some of these things happen. But we should learn as a media, whether it's social media or others, not to over-sensationalize it and put it in a context. Otherwise, it gets distorted. So this kind of a caution we need to have. So
Can I just add one line? Yes. I mean, anger of the judge is well taken when it is actually accompanied by uncompromising vigilance about justice. Is it the case?
Do we have time for one last question, or should I open it up? One last question, and then we'll open it up. We'd love to hear it from you guys. Several of the essays in this book talk about the counter-majoritarian role of the higher court, the Supreme Court. Do you think, or there's a mood, and sometimes it's a progressive mood, and you see changes suddenly because the nation, I think there's a shift, there's a progressive shift which then the judiciary also catches on to. But equally, there's a regressive shift too. So even to expect that an institution can rise above the mood of the nation, is that a sort of a practical expectation? That's my question. And I'd like...
I'm an eternal optimist. See, till NAS Foundation happened, people didn't think, 2 judges of the High Court could actually decriminalize Section 377. And when Justice Shah and I saw adults break down in court, it was a turning moment, right? So those are the moments that reaffirm the question that you're asking. And these moments do happen. And like I've just said, it should happen more often. And that's the hope that people live with. And I think we should carry on with that hope. Like on this abolition of death penalty, you will have very polarized points of view. People feel very strongly about the kinds of punishments that should be meted out. This debate about punishment as a deterrence that Vrinda talks about. In fact, Vrinda's chapter brings out what you're exactly saying. Judges are now playing to popular sentiment and making pronouncements in their orders, answering that popular sentiment. And that can really distort justice. But we're having this other very healthy trend where judges of the Supreme Court are slowing down the awards of death penalty. They're having to give more reasons, finding out more grounds, and sending people for observation. In the sense, probation reports are being called forth. So they're building into the requirement of the law, which makes it more difficult for judges to easily hand down a death sentence. And this is a trend we're watching in the Supreme Court. So both these trends are continuing, and that's part of how society functions. I would call it a churn. Like in a democracy which is at work, This churn will be there and it will get reflected in the Supreme Court. I think it's healthy. And I'm an eternal optimist. I think the court will be able to rise to being what it is meant to be.
I just want to add one point and then I'll give it to you. This thing that you mentioned, decriminalization of same-sex relationships. Do you really think it was, I feel like the society, there was, the media was for it, there was enough activism around it. I think it was actually a very easy judgment. It wasn't contrarian, it wasn't going against the majoritarian because...
Manisha, yeah, you're talking of 2017, I'm talking of 2009. That's the difference.
Majoritarianism, can we look to the court as a counter to it, and has that happened?
Look, I share the sentiment expressed by Justice Muralidhar about optimism. Because in our society, what is wrong and what is right, even those ideas keep on changing. And I see the same trend. I want to share something with you. My father was a district court lawyer. When I joined practice, he had already put in about 28, 30 years of practice. And what today senior lawyers speak about judges, in our days, great judges were there. Same thing I was hearing from my father, same thing I keep on hearing from senior lawyers who are here today. So right and wrong, they are relative concepts. But on a serious note, we must be aware of very high expectations of common man from the court. And therefore, it's a challenge. It's a challenge. And I, as somebody who belongs to legal fraternity, I can't say that we are done so well because there was one Justice Krishna here. Because you need same judge. I can't say that there was Justice Vivian Bose or a few decades back. We need more judges like Justice Vivian Bose. So it's a question of really facing the challenge. And we can't face challenge unless we have debate. Debate inside the judiciary. Debate about listing of cases. Debate about giving priorities. I believe only in one thing, that we have never discussed the issue of giving priority. What is this talk about giving priority to cases of senior citizens, somebody who is above 60 years? I am talking about common man's perspective and very logical perspective. If we have second appeals in the High Court where third generation of litigants are the parties, can you say that give priority to case of 60 years old? You will not give priority to cases of third generation litigants. So therefore, we need to work on our priorities. Which cases should be given priority? In fact, I have gone on record in saying that when we have litigation of common man, can we say that we should give priority to commercial litigations? In fact, I have said on public platforms that how commerce can be associated with litigation. Litigation is litigation. And why we have that enactment, we say that give priority to commercial litigation, give priority to arbitration matters. Keep aside people in jail. Common man has to go to the court, woman has to go to the court for maintenance, somebody has to go under this Domestic Violence Act. Some tenant has to go for enforcing his rights under the Tenancy Act, where he is entitled to become owner of the agricultural land. So these are litigations of common man. And therefore, we must work on priorities. Only if we work on priorities, then we will be able to say that we'll be able to restore faith of common man in judiciary. It is not only about dealing with cases of those who are languishing in jail. It is all about cases of very poor people, very ordinary people who come to the civil court or criminal court with the great hope that they will get justice. So therefore, someday we'll have to think about our priorities. Should we give preference to arbitration? Should we give preference to commercial cases? That's the question.
Professor Guru, you want to come in on counter-majoritarian?
No, I am worried about something else.
Okay.
I think Alwa's essay makes this point, a very important point, that Justice Nariman, sorry, wrote 2 volumes as to how dissents were converted into land of the law. Now, my academic concern is that in what sense it was an improvement or on the dissent that was expressed some 10 years back. And that would perhaps answer most of the question as to what should be the nature of the judiciary in this country. Right. Yeah. I can't have any projection or conjecture to make. The second point is, and as far as I am an outsider, and you are around me.
I think we've established you're not an outsider.
Okay. Thanks for accommodating me. I think our judges, and I'm reading some cases, that they are for achieving perfection for positivism, whereas Justice Krishna Iyer or Advocate Indira Jaising would give some kind of a normative height to your judgment. Now you have to make a choice. You want to achieve positive perfection or positivism, meaning heart and Dodkin. So that's the simple thing. So that is how one has to handle this. If you really want to create faith in the judiciary, faith of the common people in judiciary, and some previous CJI said no. People's sentiment, what did he use? And some essay, people's sentiments need to be represented in the judgments of the people who display justice. Now, which people, I have no idea. It's a very ambiguous term, you know.
Great. Thank you so much. With that, let's take some questions, and please keep your questions brief and make sure that they're questions, not observations. Okay. Okay. Please. The mic there.
I don't know why we have not addressed the elephant in the room. And since we have Justice Oka on this panel, I want to ask a direct question. Since you said ask a question, otherwise I would have rendered a little speech for you. But I believe in protesting in real time. If you want to make a change, this answers your question. Are we interested only in dissents, which will become the law of the land 10 years later, or are we going to protest in real time? So my question today is this: how does the collegium function in the secrecy that it does? Today we have a dissent by the sole woman judge on the Supreme Court in this country who said she disagreed with the decision which was taken by the majority of the collegium, appointing a junior judge who will be the future Chief Justice of India. I want to know what are the criteria for selecting future Chief Justices of India. In my opinion, they are ideological. A majoritarian Hindutva government wants its own people in the judiciary, and what have you judges done about it?
My God.
What is the lure? What is the lure of post-retirement that beckons judges? We want an answer to this question. Madam, is that a question enough?
It's more than a question, and we expect nothing less from you. So, would you like to take that? Would you like to take that?
Directed against me, I guess. In a lighter vein, firstly, I am happy that I am not part of the collegium. And I was the part of collegium only for 6 months. You know, this is a question of great deal of concern. And in fact, I have been saying this. We have to define what is transparency. You are right when you say that if one judge has dissented, we must know what is that dissent. There is nothing wrong with that. And you may be justified in criticizing why that dissent is not on the public domain. That is one thing. Other question which is asked every day to me: why the deliberations and minutes of collegium are not being uploaded. Today, you talk to any Chief Justice, any retired Chief Justices are here. Today, it's a task in hand for Chief Justices to persuade successful lawyers to accept judgeship. Collegium considers cases of say 10, 15, 20 lawyers When collegium will say that A is not up to the mark, B has some doubtful reputation, C has something. Are we not concerned with privacy of those individuals who volunteer to give consent? Because if 10 cases are considered, 5 will not be recommended. Other 5, if it is on public domain, they have to go back and practice. So issue of privacy is also there. There was some resolution of the Supreme Court recommending High Court judges. Even income of that particular lawyer for last 3 years, even that is part of the resolution. So we have to balance it with privacy. And when there is dissent, I fully agree with you that we must know why that dissent is there. There you are absolutely right. We need a lot of thinking about it because there are pros and cons about it. Some people believe that, only because we have entire resolution on public domain, it brings about transparency. Perhaps transparency, wider issue, transparency has to be in the process which is adopted by High Court Collegium and up to government. But this issue requires debate, and I'm glad that you have started that debate.
The gentleman there with the check shirt.
This is a question. Unfortunately, I have respect for Justice Oak, but I deeply disagree with one of the judgments he has passed relating the Bhopal disaster case. Just some background information required.
Sir, please
No,
stick to questions.
No, question
For
will not
observations,
answer-
we can be after the...
There was a settlement in 89 on the basis that there was only 1,05,000 injured. And
But we need
that-
questions. Please,
No,
like if you have a pointed question.
Yeah, you won't understand the question
No,
unless
after
I
that,
give some background.
No, sorry. Just a pointed question if you have one. Otherwise, we, after the this conversation, you have ample of time to
What
discuss.
the issue is.
Okay, go ahead.
See, at the time of the settlement, there were 6 lakh claims, but the Supreme Court came to order the judgment on the basis that only 1,03,000, 5,000 people were affected. Why they omitted 5 lakh? No explanation, even without a preliminary examination.
Okay.
And the Union of India challenged that settlement. Union of India was part of the settlement. Then subsequently, after 16 years, the Union of India challenged the settlement through a curative petition, of which Justice Oak was one of the members.
So do you...
And
okay, so
the point is...
Sir, yes, let's answer because sir, we don't have time. We have to take other questions also. One pointed question. We've understood the gist of what you're asking.
Yeah,
Let him answer.
how did he agree to a point? Why did you not disagree? How is that a settlement which was based on 1,05,000? The same amount, the settlement, the amount was given to 1,05,000 was dispersed among 5,73,000.
Okay, sir.
And not a penny was increased.
We got
And
the
challenged
question.
through the curative petition. And what basis did, Mr. Sanjay Parikh is here. He was.
So we got the question now. We need the.
No.
I'm sorry, I'll have to be rude and I'll have to cut you down. Because we
No,
we want time for other
on
people
what
also.
basis
So he's going to answer this, and then we'll have to.
The claims
we'll have
of
to move
5
to the other
lakhs,
question,
on
please.
what basis was it rejected?
Question well taken, please.
2 things. I was part of 5-judge bench dealing with the case where virtually review was sought. Firstly, I respect your right to say that judgment was wrong. I am no longer part of the judiciary in the sense that I had demitted office. But even if I had demitted office, I have constraints. And I will not say on public platform why I have taken a particular decision. It is for you to read the judgment. It is for you to criticize that judgment. You are right to criticize. And you are right to say that judgment is wrong. But I have my own constraints. I am party to that judgment. And I will not defend my judgment on public platform because it will be inappropriate. Because I was not the only judge. There were 4 other judges. So while I respect your right to criticize the judgment, I will not answer this question.
I see a hand going up there, right at the back. Yeah, yeah. Oh,
Hello.
you and then that gentleman there. Yeah.
Hi, good evening.
Yeah.
This may sound a little controversial, apologies in advance. So I'm born and raised in Saudi Arabia. I was a news anchor for Saudi television. I've been with the BBC in London as well. So my question is very simple. And again, it's sounding women-centric, but it is what it is. Despite all the conversation and debates that happen around women's safety, are we genuinely going to have a situation where women, will feel safer? I live in Dubai and Saudi most of the times, and then when I come back to India, as much as I love this country, I do not feel safe. So everything that goes around, will we ever have maybe capital punishment, maybe stricter laws? That's one. And second, I understand it
Your
is
question
controversial.
taken, please.
And just another question. Also, just 2 days before I was coming back from Jammu.
Okay, ma'am, we don't.
and
I said we don't
just-
have time for observations.
the
Just
quick-
specific questions. I
The
hate to be
specific
rude.
question. This is the specific
What are
question.
we doing enough? Are we doing enough about women's safety?
Right.
That's the
And
question.
the second question is, 2 days before coming back from a flight from Jammu, I happened to do namaz in my seat,
I think I have to tell the person with the mic
and
to please
and the passengers
give it to-
beside me asked the seat to be changed just because they saw me praying. The only question, pointed question, is this: as a Muslim, and I speak for Muslims around, will we ever have
we
a
have
situation
the person
where
with the mic?
where we feel safe enough to perhaps carry on life as usual?
Okay.
Thank you very much.
House rules, guys, please. We don't have much time, so we want actual questions addressed on the conversations we've had. If anyone would like to take that, we can. But I don't think that's a specific question that anyone here. It's a question that involves a lot of things: policing, society, education. So I don't know if I want to specifically ask that question of anyone else. But please, now I'll be very ruthless. So specific questions based on the discussion we've had now. Gentleman with the cap. Questions only. Otherwise, I'll have to ask the person with the mic to take the mic away. Sorry.
We've discussed about bail. I wanted to know the opinion of the panelists of various states using preventive detention laws to detain people.
Okay. Would you have that to anyone specific, or you want anyone to comment? Would like to comment on that?
I think two different things. We are discussing bail. You are discussing preventive detention. Now, as far as preventive detention is concerned, law is so clear that procedural safeguards have to be followed. If they are not followed, court will have to issue a writ releasing the person. But two are different, totally different concepts.
Yeah, I think if you mean what are the courts doing about preventive detentions, I think you have a genuine concern. Usually these detentions are for a short period. They're meant to be for a short period. Preventive detention law is used to keep the judiciary out. Normally when you're arrested, you'll be produced before a court. If you're preventively detained, you're produced before a board. And that board can sit within 3 months. It can confirm your detention. Our own statistics in the Delhi High Court is 90% of all these detentions are confirmed. By the time it's challenged in the court, 10 months have gone by. Usually even those very progressive judgments you read at the Supreme Court or the High Court squashing a detention happens at the end of 10 months and 11 months. Just as Oak mentioned about priority. There are high courts which are not giving priority to habeas corpus petitions. It's a matter of serious concern. There are times when the Supreme Court has not taken up the issue of habeas corpus petitions not being given priority in a place like Jammu and Kashmir. So it's a very serious concern that states across the country are using preventive detention laws to keep the judiciary out, to deny basic protections. And it's an unfortunate episode in our constitutional history. Rohan has written about it in a separate book altogether, that in our Article 22 of the Constitution, we legitimized preventive detention. Something that was a colonial hangover, it is a relic of the colonial past, has come to become entrenched in our present system. And it is actually, putting away people for political reasons because you do not trust the judiciary, you do not trust our own system. So we need to do a serious debate on preventive detention laws. And that requires, again, another debate or discussion.
One more thing. Actually, my experience as judges, these matters don't require much time to decide. But the positive thing I want to tell, there was a Chief Justice in Bombay High Court who gave specific assignment of preventive detention matters to me for 1 year, complete 1 year. So he was conscious of the fact that these matters should be given priority, and that has to be followed everywhere.
Actually, you are making the point I'm making too.
Right.
See, it's all become very Chief Justice centric. One thing we didn't discuss is master of the roster. So, our institutions are all Chief Justice centric, and that needs another debate. You'll find enough articles, enough essays in this book for you to ruminate. Yeah.
The gentleman in the green kurta.
Yes, please. Yes, please.
You have rightly concentrated on criminal justice system, but don't you think that the whole system is actually not working? You go to any tribunal today, let me tell you honestly, the judges sit at 12 o'clock and they're up at 2 o'clock.
So-
Nothing is being decided. The system is actually failing.
So,
Very serious.
Anand, the 3 interviews, in those, I mean, Indira Jaisingh's interview,
No, concentrate. Do you agree that the system of administrative tribunals is just not working?
absolutely, there's no question at all. And no, I'm just saying the book does discuss. In the panel, we couldn't discuss everything. In the book, you'll be interested to know that not only Indira Jaisingh's, but Meenakshi Arora, and to some extent Sriram Panchu, the 3 interviews deal with this, what you're precisely saying. And it's a failed system. The tribunal system is a failed system. It's been commented upon by several judgments of the court. So,
Okay, the gentleman in the green kurta, he's been standing for a long time. Your turn.
So my question is directed to, I'm Advocate Vishwas Tavan. My question is directed to Justice Muralidhar and Justice Oak. Since both of you have been on the bench for a significant amount of time, one of the main problems that comes in the way of even good faith criticism of certain judgments of the courts is that at some times the way the criticism has been framed, sometimes it is important that we have such provisions in place, like the contempt of court provisions that we have. So, but there are also enough instances, as has been pointed out by Advocate Abhinav Chandrachud in his book Republic of Rhetoric, that certain very good faith criticisms of certain orders by the honorable courts have been taken in purview under contempt of court provisions. So how do we balance a good faith criticism of the judiciary? And if I'm allowed to be a little honest, there is a certain gradation as to who is allowed to what degree to criticize the courts. The senior members of the fraternity have basically they have a freer reign when it comes to certain criticisms, while younger members of the bar, such as myself, and people who are not from the bar, people who are social activists, people like that, it is very easy for them to fall under contempt of court proceedings. So how do we balance that?
no, I can only say the judiciary keeps saying that it has broad shoulders, but I'm afraid that the size of the shoulder keeps differing.
You want to come in, Professor Guru, and then of course Justice Oak also.
No, not really.
Can you point out some instances where there was a bona fide criticism and contempt proceedings were initiated? Can you pinpoint a case?
Not off the top of my head as of right now, but instance wherein he tweeted the court. So that was a very valid, in that instance it was very valid that the court took contempt of court proceedings in that case, even though his intentions might have been good. I cannot comment on his intentions. But the thing is, when the grounds become murky like that, where can we draw the line? What kind of criticism can be accepted? Or what, in what
Okay, so next question. I think he's answered, but we don't have much. How much time do we have now? 2 minutes, 5 minutes. Yes, please. Quick, one question. Yeah.
So I just wanted to ask that on the bulldozer, there was one observation, and then it was very clear that it will not be a revenge bulldozer. But
And it's
we are
continued.
seeing across the country that the revenge bulldozer is going on.
Yes.
And there is no action either from High Court or from the Supreme Court. Even the Supreme Court is not taking care of its own observation on bulldozer. So how it is possible and how to report on? I wanted to ask about 2020 also, but
That's
anyhow,
an
I have a
excellent
one
question,
option,
Atli. And the question is that why can't you just act? There is an order that says that you cannot go around bulldozing houses. You want to take that? You want to take that?
I think we've all wondered this. As a lawyer, I still wonder that. Because, you've just laid down a judgment. Somebody's coming to you and pointing out this judgment has been violated. And that case is not listed in good time? And these are questions that plague me still. And I don't know, I think the judges have to answer this. The present judges who've delivered those judgments have to answer this question, because there is the laxity in implementation, and they should, this is what we call a continuing mandamus. So some cases should not be closed with the judgment. This is what I personally believe, having been a judge for 17.5 years. There are some issues even when you deliver the judgment, that unless you keep it for monitoring before yourself, the executive is not going to implement it because of various other, considerations. So it is up to those judges who deliver those judgments to craft the aftermath, the proceedings following it. Until they make sure that these have been, properly down the line given as instructions, they're shown to the court that these instructions have been issued or the rules have been amended, my own feeling is those cases should not be closed. So this continuing mandamus could be one device that in some of these cases the judges should, deploy.
Can I just say something about this? Yeah. I'm sorry, just to join issues with you. I mean, it's very important to close the cases. The closure is important. But if you keep the case boiling, some kind of pragmatism in the law. I mean, the law by rules is one thing. Keep discussing about the cases, keep them open. But are we not really interested in really closing the cases on the matter of principle, law as principle?
No, so you may be right in certain kinds of cases that you need a finality. But there are some cases where the mandamus that you issue, let me take the Nalsa judgment for instance, transgenders. You gave a long judgment, you made several declarations, and you anticipated that they may not be implemented. So ultimately people have to come back to you to say, listen, you've given a good judgment, but it's not getting implemented. So they devised, so this device of continuing mandamus is not deployed across the board in all cases. There are certain kinds of matters where it is very effective and it is necessary for the court to keep it before itself for monitoring, because it has huge ramifications. Because the implementation of the judgment is dependent on corrective action by the executive or by other bodies. And if the pressure is off, it's like the foot off the pedal. And you have to come back. Not many people understand the contempt dockets in our high courts and even in the Supreme Court is fairly huge. A very large number of contempt petitions come. And let's say Justice Oak has delivered a judgment, right? And then Manisha is the next judge dealing with it. Justice Oak has left the court. She doesn't agree with Justice Oak, right? The contempt petition complaining that Justice Oak's directions have not been complied are before her. She doesn't give it priority at all. This we see actually playing out. So Justice Oak should then anticipate this. And Justice Oak should not wait till the last day of his retirement to lay down a judgment. I'm saying even judges do and have to strategize. I'm sorry to say this, but we have to. And Justice Oak will be the person who will agree with me most, that the minute Justice Oak has left the court, certain kinds of issues will not be taken up at all. They will disappear. So I've asked that question to Professor Bakshi, where I said, there are these cases of vanishing cases. Justice Madan Lokur headed a social justice bench. Today there is no social justice bench in the Supreme Court. So that it all again comes back to what Justice Oak was saying, priorities. And the concern that, once we have taken the law 2 steps forward, we should take it to its logical conclusion. Yes. It's in that context that I said continuing mandamus, not all cases across the board.
Great. With that, I think we'll have to wrap the session up. Really sorry, can't take any more questions, but there will be a conversation after this. I think the lady here brought up a very important point on bulldozers, and I think that's a great example. I feel that there is a public mood, and so there's not enough will to crack down. Because you have media celebrating it, you have the politicians very proudly saying that we are doing this. It appears to a person as an observer that there's just not enough will to crack down on something that's popular. So thank you so much for joining us, for being so patient. I'm sorry if I was rude in interrupting some of your questions, but we had little time. This was really lovely and a really lovely evening. No, but they're going to be here after this. They're going to be here after this, so we can continue this. I really have to wrap.
2 minutes. I've been raising this beginning.
Provided it's like one. Okay. Last. But is that a question or an observation?
It's a question. Question is that it It took us 10 years in Supreme Court for the matter to come up. Petition filed in 2003, got activated in 2013. It's a homeless matter, people suing for the Delhi. And then when the matter comes up, we have in the last hearing, the current Chief Justice has become, he makes a comment on the homeless
But
people.
sir, there's been no question. I've heard you patiently. This is an observation.
Murli,
Okay.
the homeless people are parasites. I think
Noted, point noted. We can have this observation after this. Thank you so much, sir. I'll have to stop you there. Point taken, and we can. Sorry, no more questions, guys. Sorry, you can talk to them after this. Yeah, it's become a.
Thank you all for being such a wonderful, engaged audience. There are books outside.
There are books. Please don't forget the book. That's the most important point of all of this. Please get the book.
Please